Good evening. I'm Steve Target, Chair of the Program Committee of the Union League Legacy Foundation. It's my pleasure to welcome you to tonight's Public Affairs program. The Legacy Foundation is the nonprofit charity of the Union League, guided by the United States Constitution, the history and values of the Union League. The foundation's goal is to create more informed, more engaged citizen leaders, and we do this through dozens of programs, lectures, and exhibits, including programs like tonight's Public Affairs program. All of our programs of the Legacy Foundation are made possible through voluntary contributions from Union League members and others in the community who share our values. Thank you to all of the generous donors for making these programs possible. Well, tonight's program is going to run about an hour in length, and towards the end of the program, our guests will take questions from our audience. To ask a question, simply use the Q&A box located at the bottom of your Zoom screen, and we'll try and get to as many of these questions as possible. Now, it's my pleasure and honor to introduce the moderator for this evening's program, the Executive Director of the Union League Legacy Foundation, Mr. John Miko.
Thank you, Steve, and welcome everyone to this really fascinating and I hope informative discussion about the Supreme Court. I'm thrilled to have two constitutional scholars and friends of the Legacy Foundation with us this evening. Let me introduce them first, and then I'll do a few other housekeeping items. First of all, we have Michael Gerhardt. Michael is the Samuel Ash Distinguished Professor of Constitutional Law at the University of North Carolina School of Law in Chapel Hill, North Carolina. Gerhardt has worked and testified in Senate confirmation proceedings for the Supreme Court justices, and about a year ago testified before the House Judiciary Committee regarding the constitutional grounds for impeachment of Donald Trump. Michael has been involved in many things here at the Union League and in Philadelphia. He's a visiting scholar at the National Constitution Center, and he's one of our participants annually in Good Citizen Day, where we try to inform our good citizens, our Union League good citizens, about the Constitution and civics, among other things. Michael Moreland is Professor of Law and Religion and Director of the Eleanor H. McCullen Center for Law, Religion, and Public Policy at the Charles Widger Villanova School of Law. He served as Associate Director for Domestic Policy for the White House under President George W. Bush. And both Michaels have great experience right in this wheelhouse in terms of the Supreme Court. Michael Moreland mentioned earlier that he was actually a page during Robert Bork's nomination process, which we'll talk a little bit later about, and is a colleague of Amy Barrett's when he was a visiting law professor at Notre Dame. And Michael Gerhardt is actually fresh off of being in Washington, D.C. for the most recent Senate confirmation hearings with Justice Barrett and the Senate. So one other piece of housekeeping, if I may. We are offering CLE credit through our co-sponsor for tonight's event, McCullen Center for Law, Religion, and Public Policy. Michael, thank you for making that possible. And for everyone who is watching and expecting to get CLE credit, you're going to need to pay attention to this word, and the word is Lincoln. There'll be other words later in the program. And you will receive via email, for those that are signed up for CLE credit, a smart sheet will be emailed to you later in this program. So again, that word is, for all of our CLE credit people, Lincoln. So gentlemen, welcome.
Thank you.
So we have a lot to cover in past, present, and future of the Supreme Court. So we like to, with all these programs, give a little bit of history and understanding. And so I'm going to first ask Michael Gerhardt, would you give us a little bit of Constitution 101 with regards to the Supreme Court? What does the Constitution say about the Supreme Court? What doesn't it say about the Supreme Court? And take us through some of the early years of the formation of the court.
Okay, thanks, John. I really appreciate the chance to be here. Hopefully I'll be back there in person someday soon as well. It's a good time to talk about the Constitution. And one of the things to understand about the Constitution, of course, is it creates three branches of the federal government: the presidency, whose job it is to enforce the law, Congress, whose job it is to make the law, and then the courts. In fact, the Constitution mentions only one court. It says there shall be one Supreme Court. It also leaves to Congress the authority to create lower court judgeships, lower federal courts. And Congress also has the authority to determine the size of the Supreme Court. And so when Washington was our first president and came into office, he was able to populate the entire Supreme Court with his nominees. And the way that's done is the president nominates people, and then the Senate considers whether or not to confirm them. All of his initial nominations were approved, and Washington's people dominated the court. But I should point out the first Senate rejection of a nominee occurred when President Washington nominated John Rutledge to be Chief Justice. Quite remarkable. Our first president also was given the first rejected nominee. And that pretty much set the stage for the rest of history.
Michael, let me interrupt. How many justices did Washington nominate?
It began with 6. And that number is going to increase and shrink. It increases and shrinks until about 1869. We're going to fast forward a little bit because everything about the court turns out to be extremely important politically. The court is almost always at the center of some political crisis or controversy. It might get dragged in there, or the court itself might be the controversy. And this, of course, happens later when the court issues the opinion in Dred Scott, which essentially constitutionalizes the right to own people as slaves. And Abraham Lincoln, mentioned earlier, turns out to be very important because Lincoln has a chance to make a number of appointments to the Supreme Court, remarkably a lot in a very short time. 5 before the end of his first term. Unbelievable. So he really reshaped the court. The problem, as we all know, regrettably, is Lincoln is killed. And then Andrew Johnson becomes president. Nobody liked Andrew Johnson, including the people in Congress. So what Congress did is it prospectively abolished 2 of the seats on the Supreme Court. So when somebody died or it became vacant, the seat vanished. So the court actually shrank under Johnson. But then when Grant comes into office, Congress reconstructs the court and settles on 9. And so 9 becomes the magic number after that. And the court will have 9 members through the rest of all its controversy.
Michael, how does it become 9? What is the mechanism that makes that happen?
Well, Congress will pass a law, and the president will usually sign it, and that will add or subtract a seat on the Supreme Court. So it's all set up in the Constitution. It's all permissible, but it's a question of judgment. Do we want Congress making that kind of judgment? Do we want presidents to be that involved in it? Do we want to enhance some president's power? Do we want to actually subtract from some president's power? Are you on the Lincoln team or the Johnson team? So it's been a question throughout American history whether the court should be expanded, but Congress has never taken that invitation, even when Roosevelt offered it, because Congress, I think, finds 9 to be a kind of optimum number.
So, Michael Moreland, take us from there, maybe up to what Michael Gerhardt just mentioned, into the Roosevelt years.
Right. So after the Judiciary Act of 1869, the court has 9 justices, and as Michael mentioned, that pretty much remained stable right up until today. The one time in which this became a hot potato, though, was during the New Deal era, when the court, in a series of decisions, held that various provisions of the New Deal were unconstitutional. And in objection to that, there was a serious proposal floated by the Roosevelt administration to pack the court, to expand the number of justices in order to safeguard the New Deal. And that kind of culminated in a fight in 1937 in which, after some serious congressional opposition, the Roosevelt administration backed down. But the court itself also began to decide cases in favor of upholding the constitutionality of New Deal legislation. I should say, for history buffs, there's a kind of a vibrant dispute about whether or not, in fact, the court actually buckled to political pressure. The thing we always hear is the switch in time to save 9, that Justice Owen Roberts, who I learned earlier today was actually a member of the Union League, a graduate, twice graduate of the University of Pennsylvania, who cited in a case called West Coast Hotel versus Parrish in 1937 to uphold provisions of the New Deal minimum wage statute. He was the one who switched over, so to speak. And again, the kind of conventional story is that this was because of political pressure. But for anyone who's a real Supreme Court nerd, I commend the book by my friend Barry Cushman, Rethinking the New Deal Court, in which he argues that it wasn't really political pressure. It was really that the court itself developed a set of doctrines around the ability of Congress to legislate pursuant to the commerce power, and that it wasn't buckling so much to political pressure. But again, that's for the real fans of kind of Supreme Court history, whether or not it was political pressure that eventually caused the court to acquiesce to the New Deal, or whether the court basically was heading that direction anyway in a series of decisions that went back earlier in the 1930s. But the Union League and Philadelphia's own Owen Roberts was very much a part of that story.
And so at that moment, then Roosevelt kind of retreats from this, packing it to how many did he want?
I think you wanted to add, was it 3, Michael? 3 or 4?
I think it was 4.
4, okay, 4.
And so then we keep 9, and here we are today. So let me ask Michael Gerhard maybe. So we go from the story, as I understood it, is, these things weren't so political, at least for some relatively recent history. Now we know that sometime they were, and we look at confirmation hearings and non-confirmation hearings, just confirmations in the 60s, 70s, and into the 80s, where we have wide majorities or unanimous, right? We have some of those, not entirely. There's exceptions to all this, but then we have this Bork nomination. And I did ask both of you earlier if this is okay to kind of fast forward to this moment. So Michael Gerhard, give us the basic 101 of the Bork confirmation, and then we're going to talk about how that has changed the way we do this.
Well, since Mike Moreland was there, it's going to be a really.
I'm going to get to him.
It's going to be a tough test for me. I'm going to have to get all the accents right and all the characterizations perfect. When we get to 1987, there are a number of different things already happening, and that's a big part of the story. Is to understand there are already a lot of things happening. President Reagan is in his second term. He has made transforming the judiciary a top priority. The platform he ran on pledged, among other things, to appoint justices who would reverse Roe versus Wade. And he's been very successful up until 1987. But what also happens in 1987 is the Senate majority changes. And then the new chairman of the Senate Judiciary Committee is a guy named Joe Biden. And so the dynamic is different for Reagan and his nominees going into 1987, but there are a couple other things to keep in mind as well. And one of them is that President Reagan wanted to transform the judiciary because he believed that the judiciary had become much too active in recognizing rights that were not in the Constitution and interfering with small d democratic process. Big example of that in modern day, even for President Reagan, would have been Roe versus Wade. It's not the only example. A decision that recognized a right to choose, but of course that right's not spelled out expressly. Where do you find it? And so tremendous controversy because of Roe and other similar kinds of cases that then bring us to 1987, when the court at that point has the swing justice, the person in the middle of the court, Lewis Powell, appointed by President Nixon, choosing to step down. Suddenly, President Reagan wasn't just naming new people to the court. Chief Justice Rehnquist is there already. Justice Scalia was already there. Justice O'Connor was already there, appointed by President Reagan. But now the president had a chance, by appointing this next justice, to appoint somebody who would become the center of the court and therefore transform it in reality, put it on a whole new path. And the president chose a very eminent individual to take that spot, take the vacancy, and that was Robert Bork. Robert Bork, very distinguished man, expert in both antitrust and constitutional law, which he taught at Yale, both of them at Yale. He'd been a Solicitor General under President Nixon, been a very distinguished judge on the second highest court in the land, the U.S. Court of Appeals for the District of Columbia. Nobody could doubt that Bork had the credentials. But one thing that Bork also had was lots of opinions. And because he'd been around for a long time, he had opined on all the big cases of the era. And he was almost always on the wrong side of those cases, as far as popular opinion goes. He didn't think Congress had the authority, for example, to pass the 1964 Civil Rights Act. He didn't think the court had the authority to, of course, issue Roe versus Wade. A lot of cases. He'd even been critical of Brown versus Board of Education. And Judge Bork argued that the reason why these cases were wrongly decided is because they didn't comport with original meaning, or in his words, original understanding. Judge Bork was also an advocate for something called judicial restraint. He didn't want the courts to be injecting themselves into the middle of social controversies. He thought the best thing for the court to do was to be out of those, step away from them. So what his hope was to help the court get out of a lot of these political controversies and allow the other branches to handle them. So there's a lot at stake with Bork. A man with great credentials. Now the Democrats have a chance to kind of check the president's judgment and keep the court maybe from transforming too much in what they thought was the wrong direction.
So let me interrupt you there, Michael. Let me ask Michael to comment on a couple of things that you mentioned. And one was that Bork was out of step, maybe you didn't use that term, but with popular opinion and with the general feeling of the populace, and that because it was going to tip the balance, as it was currently, that would be a reason for the Democrats to oppose him in the. And I'm kind of taking a little bit of liberty here. Michael, comment on those two things in particular, and is that a reason? Is that a reason for them to reject him as a Supreme Court justice?
Well, that certainly the Senate Democratic majority at the time did, and it really, as Michael Gerhardt mentioned, it really was driven very much by the politics of the Senate. In the 1986 midterm election, Senate Democrats had picked up seats in Florida, Georgia, Alabama, North Carolina, held an open seat in Louisiana, and largely in part because of African American support for those Democratic candidates. And so when Judge Bork was nominated in the summer of 1987, the civil rights groups mobilized and conducted a ferocious campaign of opposition to the nomination. Some people remember there was a famous floor speech by Senator Kennedy in which he talked about Judge Bork's America being this dystopian place. There's a famous ad in which Gregory Peck provided the voiceover in a TV ad in opposition to Judge Bork. And so that simmered all summer long. And so by the time the Senate took up the nomination in the fall, the politics of it were really kind of already baked in. And as Michael mentioned, I mean, the hearings are actually, I mean, they're even today still kind of worth going back to. Judge Bork, I'll put it this way, subsequent nominees have been much more reluctant to discuss their constitutional philosophy, their views about particular cases. Judge Bork's hearings were very much a kind of almost kind of freewheeling constitutional law seminar, but they did highlight the ways in which on cases like Roe versus Wade, in his commitment to a form of originalism and constitutional interpretation and other matters, that his views were painted as being out of the mainstream and politically unpalatable. Of course, I think some of those attacks were a little overstated and in many ways unfair to Judge Bork. But there's no doubt that at the end of the day, the politics of it ran against him. In fact, I did the math recently. If you take the 11 states of the Confederacy and their 22 senators, he lost those senators 6-16, which is kind of amazing to think a Republican conservative nominee in 1987 only got 6 votes in the southern states of the Confederacy. It shows you how the politics of the Senate itself has changed between then and now. And just one other thing I'll underscore, picking up on other things Michael said, is that this really was a culmination, but continuing on through today, of an effort by conservatives, beginning really with the Nixon campaigns in 1968 and 72, to correct what they saw as the excesses of the Warren Court and then subsequently the court under Chief Justice Berger. There were a lot of good things, of course, Brown versus Board of Education, notably, but there are a lot of things that conservatives thought were, as Michael said, in which the court had inserted itself into political disputes where it didn't belong and had been kind of activist in certain ways. And so this was an effort that really began in earnest in the 1980s with the nominations of Justice Scalia, the failed nomination of Judge Bork, and in many ways has continued right up to today with the efforts to continue to appoint justices who will reflect a more conservative view.
So this has changed the way we do Supreme Court confirmations. Quickly, Michael Gerhardt, I'm going to ask you, can you tell us how it has changed and what it has meant since then? And bring us, then we're going to talk about our current nominee and what's been happening down in DC.
Well, John, actually, it's a fairly big question, even a somewhat controversial question about what has changed. I'm not sure everybody would agree. I don't, if I took a survey of the dreaded constitutional law community, I don't know if they could agree precisely on what it is that changed. But I think there's a perception, backed by reality, that one obviously big change is the 24/7 news cycle. Television wasn't around, obviously, in the 19th century. It wasn't around for much of the 20th century. And in its absence, there were some hearings of justices or with justices testifying, but of course they didn't command much attention. Now with Judge Bork, timing also hurt him in the sense that television was coming into its own at that point, and he was on TV around the clock. And some people argue, unfortunately, that even his appearance hurt him. A bearded fellow looked like a Ivy League law professor, which of course he was, and talked like one too, which doesn't help you that much. But doing that on television meant more people could see it and react to it. So I think what happened in a nutshell is people learned from the Bork hearings. Michael had referred to some of this. Nominees learned not to be like Bork. Make yourself a small target, don't talk a lot. Senators learned that this could be free airtime if they could make it entertaining and significant. And the White House learned not to let a nominee languish over the summer, move faster, get it done more quickly. And so you can see how all those lessons are learned in the next series of hearings, including the one that was most recently held.
So let's talk about, first of all, what happened 4 years ago with Justice Garland being nominated, and with the Senate not taking that confirmation to a vote or anything else. And I remember at the time, Michael Moreland, you and I talked about the possibility, and we seem to be kind of living some of that reality of what's the end game of this in terms of the court itself. So here we are 4 years later. There are some similarities. There are some differences, of course, in that situation and this. Most notably that the nominee is being nominated by a Republican president, of course. But Michael Moreland, talk about what happened 4 years ago and today. What is the same? What is different? And what's this going to mean going forward? Senate, President, how's this going to work going forward?
Well, interestingly, in the Bork fight, there was a first-term senator from Kentucky who had also worked on the Hill as a staffer named Mitch MCConnell, who had, as both a staffer, but then also as a new senator, had really kind of focused on this issue, and has, people obviously, if you like him, you think he's done a fantastic job. If you don't like him, you think he hasn't, but has really, made this point about the courts very much a centerpiece of his career, both as a senator and now, of course, as Senate Majority Leader. So when Justice Scalia died in February of 2016, with an election coming up that fall, President Obama nominated Judge Merrick Garland, a very distinguished, well-regarded judge on the District of Columbia Circuit, to fill that vacancy. But Senator McConnell had right from the outset, shortly after Justice Scalia's death, in fact, I think within a day or two, had said that it was up to the American people to decide whether the president, which president of which party should fill this nomination, that the Senate would not be taking it up. And so the Senate, as they did in rejecting Judge Bork's nomination, but also in deciding not to hold a hearing at all for Judge Garland, has the prerogative to take up a nomination or not. And of course, this is what now has put Senate Republicans in the tricky position of now defending their decision to proceed forward with the nomination after Justice Ginsburg's death. Now, you can slice the onion in a thin way and say, well, but it's a president and Senate of the same party. There are statistics that 29 times presidents have made nominations during an election year. 19 of those times the Senate was held by the president's party, and in all but 2 of those times the Senate confirmed, usually not this close to an election, of course. But it sort of set the stage then for a heightening of, I'll just say, kind of the contentiousness around this, that there's a feeling that Judge Garland should have been confirmed, or at least should have gotten a hearing in the Senate, and that the decision to hold that seat open until President Trump could fill it with Justice Gorsuch was somehow deeply unfair and improper. But now, of course, with Judge Barrett's nomination, all the shoes are on different feet. Now, Republicans are saying we're going to go forward with this nomination, carry it forward to a vote. And as Democrats are saying, let the next president decide, or let an intervening election take place to decide who should be able to fill the seat.
Michael Gerhardt, would it have been any different today had the McConnell and the Senate gone forward with a nomination procedure and rejected Garland 4 years ago? Would that have made any difference in your mind?
Probably not much. I mean, rejections can take more than one form. And I think, given what Michael said, there was a general consensus that, Merrick Garland was extremely well qualified. Of course, Robert Bork was too. And one cannot help but think that what we're seeing is an incredibly long game of tit for tat. I'm going to use a different phrase, if I may. I think what we're seeing, what we've been seeing for some time, and it's really come to life with Garland and the subsequent nominations, is a vigorous game of constitutional hardball. Now, constitutional hardball basically means when branches are pushing their powers to their utmost, if not beyond. And you can see that that's what the Senate did with Garland. That may be what the Senate did with Bork. You may see that the president, of course, is trying to ensure that this nomination, not just of Gorsuch and Kavanaugh, but the nomination Barrett gets done quickly before Election Day. Why? Because he said he's got some cases he expects will get up there shortly after the election. So that's hardball. And what we might be witnessing is a new phenomenon has formed in the confirmation process, where we can expect the parties to be engaged in this constitutional hardball. The gloves are off, the fights are vicious, and what's at stake is the future of the Supreme Court.
So I'll ask this question to both of you. I think I know the answer, but will Barrett be confirmed, in your opinion? You may not want to answer that question, but this is Michael Moreland?
I certainly would expect so. The Senate Judiciary Committee is scheduled to vote tomorrow, and will report out the nomination. I believe the plan is to then have a vote to end debate, cloture and parlance of the Senate, and have a final confirmation vote early next week. One aspect of this constitutional hardball, by the way, that people can follow over the next several days is this issue of the filibuster and the way in which, first, and again, like Michael said, everyone's playing hardball all the time now, but first in the Bush administration, which I worked in, Senate Democrats filibustered, I think maybe people would say some very qualified judges who never got on the bench. Then there was a brokered compromise. Then Senator Reid, as Senate Majority Leader for the Democrats, broke the filibuster, the so-called nuclear option, changed the filibuster rules to confirm some Obama appointees. Now, but not for the Supreme Court. They didn't change it for that. Then for Justice Gorsuch's nomination, Senator McConnell once again invoked this so-called nuclear option, broke the filibuster for Supreme Court nominees. And so that's why you'll see a very close, I suspect, 51, 52 votes for Judge Barrett, which ordinarily, of course, it would have required at least 60 votes to break a filibuster. But post Gorsuch, that's all you need.
So before we get to our current confirmation process, Michael Gerhardt, what did those rules mean in terms of the justices that we wound up getting, whether they be on the Supreme Court or some of the other courts?
You mean the rules regarding the filibuster?
Yes.
Well, the filibuster has been an ancient device in the Senate, actually very unique to the United States Senate, which allows a fairly significant minority to block something. Historically, they blocked it by talking a lot and not relinquishing the floor of the Senate. In 1975, the system got changed so that one merely had to threaten a filibuster in order to take something off the docket or take it off the business of the Senate. And so threats of filibuster began being used against judicial nominees. The first judicial nominee blocked by a filibuster was actually President Johnson's nomination of Abe Fortas to the Supreme Court. Then, as Michael points out, Democrats began using the device with regard to some lower court nominees. And then eventually the filibuster itself, which was made possible because of the rules of the Senate, the filibuster got dismantled through I won't go through all the details, but through a reinterpretation of that rule. And the reinterpretation of that rule concluded filibusters are not allowed against judicial nominations. And that's the prevailing sense of the Senate right now.
So I'm going to go forward with my prediction that Barrett will be confirmed. How's that, Michael Gerhardt?
I think it's a very safe assumption.
Okay, and I want to ask Michael Moreland. So then we have a Supreme Court that has 9 again. We have a presidential election that's going to be in a couple of weeks, and I'm going to give you a scenario. Trump is elected, and we have other Supreme Court openings, and the Senate is controlled by the Democrats. What happens?
Well, I think now, as your question implies very directly, I think no matter who the president is, at least for the foreseeable future, it will be very hard to confirm a nominee in the Senate if the Senate is not controlled by the president's party, and certainly Senate Democrats, especially after Justice Gorsuch, and then after what happened with Justice Kavanaugh, and now with hope to be soon Justice Barrett, there will be sore feelings, to put it mildly. And I suspect that if there were an opportunity in a Democratic Senate to have a Trump nominee, that nominee would not be confirmed.
And Michael Gerhardt, what happens if Biden wins and the Democrats win the Senate? There's a couple other scenarios here, of course, but what happens then? What is going to what do you think will happen?
Well, John, let me just make my quick disclaimer, if I may,
Sure.
Because I've been hired to be special counsel by the Senate Judiciary Committee Democrats for about the last decade. So what I'm about to say is my personal opinion. I'm not going to speak for anybody else or any senator. But I think, assuming that Biden gets elected and you have a Democratic Senate, I think you're going to see the favors all returned. That is to say, President Trump, I think quite astutely politically, with the help of the Senate, has confirmed record numbers of judicial appointees. For example, in less than 4 years, he's appointed as many circuit court appointees, courts of appeals judges, as Obama did in 8 years. And the difference is President Trump's been able to do that with his party. Well, President Biden, if there is one, and he's got his party in control, will then try and do the same. Get as many appointed as quickly as possible to, in their view, correct the imbalance in the court system.
Will we see court packing?
I think it'll be discussed. I think it's not really being discussed in the Senate right now because, Democrats are uniquely capable of snatching defeat from the jaws of victory. And so therefore, there's no point in counting, what you're going to be able to do tomorrow unless you win. So the focus is on winning. And then we'll see what people talk about later. But I think to pick up on something Michael Moreland said, I think the feelings within that committee are extremely raw. And there's a lot of people that have been really ticked off by what's happened over the past few years. If you have time, go listen to Sheldon Whitehouse's 8 minutes in concluding the Judiciary Committee hearing last week. Sheldon Whitehouse kind of went over that and basically kind of drew a line in the sand and said, you, the Republicans, opportunity to say that we're going to object to anything we do, like what you have done, dies today. It dies today, which is, I think, his way of saying when the time comes, the Democrats are in charge, they will do everything they can to correct what they perceive to be the imbalances created by the Republican majority.
So, Michael Moreland, let's talk a little bit about some kind of practical court issues. 9 justices, 11 justices, 6 justices, 15. Most Supreme Courts in the United States, state Supreme Courts are 9, I believe. Most, not all of them.
It varies considerably.
7, Vlad. Many. What's the right number? And this is not a question of politics, but what's the right number to come to a conclusion on the kinds of issues that a Supreme Court would have to deal with?
Well, it's hard to know. I think that for purposes of the U.S. Supreme Court, it's not so much that 9 is a magic number. It's just that it's been historically stable in the practice. Now, of course, that opens up to questions about the fact that Supreme Court justices are now replaced in a seemingly fortuitous way, depending on when they retire or pass away, and the president happens to be sitting in the Oval Office to nominate their replacement. So I don't think there's any magic number. The Pennsylvania Supreme Court, I think, is 7 members, and so I don't think the number is the magic one so much as the fact that 9 has been a historically stable number for the U.S. Supreme Court, and that to pack the court, as some on the progressive left are now arguing for, would really be, I mean, granted, I understand that the people on the left feel that there's been a kind of tit for tat back and forth that's been escalated on the part of Republicans. People can, disagree about that. I happen to think that a lot of the fault can be spread to the Democrats as well. But having said that, court packing would be a serious escalation of that. It would require, among other things, just to get all wonky for a second, it would require the abolition of the legislative filibuster. That is to say, it would mean that you would abolish the filibuster for statutes in Congress, which would have repercussions that would reach a long way. And then to pack the court with progressive justices to counteract what are thought to be these illegitimate, although I hasten to add, not constitutionally illegitimate in any meaningful sense, because they've been appointed by the president after confirmation by the Senate. But after these last 3 nominations, I think that would be a very serious escalation of the judicial confirmation wars.
And how would that happen? Is there, what the mechanism is simple law that's passed by Congress?
Right, it's by
majority.
As Michael Garrett said at the outset, the series of judiciary acts going back to the founding Congress, first Congress, set forth not only the number of justices for the Supreme Court, but also the composition of the lower courts. So it's a statute passed by both houses of Congress and signed by the president. But again, given what would be the effort by a Senate Republican minority, assuming that that's the scenario, they would have to overcome a filibuster there. And that's where you do, I think, start to then get into some really dire situations involving subsequent court packing on top of the court packing, so that, okay, 4 justices are added, this time by Democrats, and because they're mad about Kavanaugh, Gorsuch, and Barrett. And then 2024 or 28, you get a Republican president, Republican Senate, and they add 4 more. And then I think you really would have a crisis of legitimacy in the court, much more serious than what you have now.
So it seems to me, both Michaels, that, and I'm no expert on any of this, but there doesn't seem to be a long view of any kind when it comes to the Supreme Court that comes from Congress, as far as I can tell. in terms of the Supreme Court. Michael, am I wrong on that, Michael Gerhardt?
Well, I think there is a long view. It's just that it's politically driven. So, or another way to put that.
Well, we have an election in 3 weeks, so that's not very long. Right.
But I think each side would like to think that it has a long view of how it would like everything to work out. That is to say, they want to be able to win, not just now, but forever. And that's what happens when you have constitutional hardball. I think the dilemma, a dilemma that could arise is that Republicans have been extremely good at playing constitutional hardball. And if Democrats get back in power, they're going to be asked to unilaterally disarm when they know the other side is playing a different game. And that will be very hard for them to do.
So I'm gonna move to some questions if I can. And we have 2 questions that in hindsight should have been asked by me first. So I'm gonna ask them now. And it's about the 2, we've been talking about Bork, we've been talking about others were mentioned, Scalia and others. Michael Gerhardt, tell us about textualism or the living constitutional theory. And I'm gonna give you 1 minute. Forgive me for giving, but go ahead. You're on.
Okay. I could probably do it in less than that.
Right.
So I think that in a way, everybody's a textualist because everybody does pay attention to the text. But the real question is, where are you going to look to inform your judgment about what these words in the text mean? Some will argue, Judge Barrett, for example, that you look to original meaning and you only look to original meaning. And then others may say, no, you don't either look there at all, or you might look there, but you could also look other places, for example, like judicial precedent, or you could look to the design of the Constitution to inform your judgment. So the real question for any textualist is, where are you going to look to define the terms you're trying to define?
Michael Moreland, I'll give you a chance to add or say anything else with regard to that.
Yeah, I mean, it's the view of constitutional interpretation. I mean, originalists would say that it's the view that's been present all along, but now has been advanced more in a more theoretically sophisticated way to counteract what is this alternative of judges kind of deciding and making up law that isn't actually in the text or that isn't in the original meaning. And so it's a way of focusing and constraining the role of the judge and constraining disagreements in the judicial process around the original public meaning of the drafters and ratifiers of either the text of statutes in the sense of textualism, which is usually how that label is applied, or in the sense of constitutional text in its original public meaning for originalists.
So here's a couple questions from our audience, if we can move to those as well. So I have one: is impeachment of sitting justices a constitutionally valid alternative to court packing? Michael Moreland, your thoughts?
I mean, I guess the question is, as a normative matter, as a descriptive matter, I guess I would say generally no. There was actually an effort to impeach Samuel Chase, in early justice, that was rejected. And so since then, there's been a pretty hard constitutional norm. Now, again, these norms are now all being subject to considerable stress, but there's been a pretty serious constitutional norm that you don't impeach judges for decisions that they make that would threaten the independence of the judiciary. Now, there have been corrupt judges that have been impeached from the lower courts, but I think that would be another kind of escalation, which, I think whether you pack the court or whether you start impeaching justices for, spurious ideological reasons, I think either one would be a quite severe and distressing threat to the independence of the judiciary.
Another question, putting aside the quote, would they or could they, isn't co-opting the court by legislative branch fundamentally inconsistent with our concept of separation of powers? And I think there's a couple of things in there. I'm going to ask Michael Gerhardt. You've already sort of commented on this a little bit, Does that question make sense to you?
I hope so. I'll take a crack at it. Well, I think, with all due respect, I think the question may be assuming its answer. So to say that the legislature somehow is co-opting the courts, I think doesn't necessarily do justice to the actual structure of the Constitution. The Supreme Court is structured by political actors. The president names the justices, the Senate confirms them. So political actors define the court. That's not co-opting it. That's the design. That's the Constitution we've got. And the same is true for the size. Congress decides the size. The justices don't decide the size. And it's true for the environment in which the court operates. Now, how the court operates is supposed to be divorced from politics. It's supposed to not be shaded by or shaped by the justices' politics or anybody else's politics. But keep in mind that President Trump appoints an Amy Barrett for a reason. He doesn't appoint Merrick Garland for a reason. And so that's a political judgment. Now, the president's entitled to make that judgment, but I think we just need to understand that politics actually shapes the court itself.
Michael Gerhardt, do you think there's this kind of rose-colored glasses view of the Supreme Court and how those things happened back in the day? I know that you're a presidential historian as well.
Well, I guess,
and I'll give you an example, Michael.
The short answer is yes.
This came up in the vice presidential debate that, Salmon Chase was that this thing was not some kind of political appointment of Lincoln's, that it was, he was doing it the right way, not the political way. Right. I know you understand that history. This is not the case.
Yeah. So I think that what happens is that we all want to believe, and perhaps really should believe, what we learned in grade school, which are there's these three branches. Each branch functions in its own lane, and largely that's true. Largely that still holds. But what happens is the actors, the presidents and senators, don't want to be sitting on the stand, are not sitting on their hands on the sidelines. They want to shape the judiciary to function as they prefer. If I may, I'll just go into that Lincoln thing just a tiny little bit, just so I can inform the audience. There's only the death of Justice Ginsburg created a vacancy for the court. It's the second closest ever to a presidential election. The closest happened when Roger Taney died. Roger Taney died in roughly around October 12th, right before the presidential election in 1864. Lincoln was obviously the president. The Republicans obviously controlled the Senate. But Lincoln decided not to fill the seat. And it wasn't because there was any issue with Chase. He hadn't even settled on Chase yet. The issue that Lincoln had to deal with was, do I do this now? We are, after all, in the middle of a civil war. Or do I do it after the election? And he chose to do it after the election because he felt that then it would be quite legitimate for him to do that. If he had not been reelected, it would have been an interesting question for him. All I can say is that Lincoln, in August of that year, had the entire cabinet sign a document in which he promised, in effect, a peaceful transfer of power if McClellan had actually won the election. So I don't know if Lincoln would have made the appointment, but it turned out he had the chance to make it anyway.
Michael Moreland, let me ask you this question. Comment on the legitimacy of the Ginsburg standard of no hints, no forecasts, no previews.
Well, as we talked about earlier, this was something of a change. I guess one would have to, kind of figure out what the hearings themselves, I should say, haven't, of course, always been true. They really only are something that comes up in the 20th century and even mid to late 20th century. But the idea here was that following the Bork nomination, when there was a fairly open discussion about precedents and about the nominee's view, the series of nominations since in both Democratic and Republican administrations. So this includes both Justices Breyer and Ginsburg under President Clinton, the Roberts and Alito appointments under President George W. Bush, and then the Sotomayor and Kagan appointments under President Obama. All those appointees, all those nominees have been reluctant to discuss not only pending cases, to be sure, which would be highly improper for a judge, but even to give a kind of indication about whether a precedent is particularly good or bad, or how it would be applied in a hypothetical situation. And you saw this in Judge Barrett's testimony as well. So it's become the norm for reasons of judicial independence. That would be one explanation for it, but also in the politics of the nomination process, that inserting oneself too much as a nominee into contested matters is just not likely to be successful.
So another question I'm going to ask Michael Moreland, and both of you actually to comment on this. How might a Supreme Court of 5, 4 lesser, or a Supreme Court of 11, 12, 15 affect the legitimacy of the court? And of course, there's a lot of politics that would be involved in creating something like that. Michael Gerhardt.
It's a really good question. I think I don't think we know the answer. I think that the legitimacy of the court always depends on what the court does. And so people look at it and they might perceive what the court has done as illegitimate. Brown versus Board of Education is one of the most hated decisions of all time. And when it came down, 28 governors refused to comply with it. They signed a Southern Manifesto refusing to comply with Brown. Threats of impeaching Earl Warren were made. It's only now when we look back and think, oh, well, was it, that was a good thing. Well, it was a hard thing for the court to do. And many people, including Judge Bork, I hate to say, thought the court was acting illegitimately when it made that decision. So some people may look at the court and think if it's ever beyond 9, it becomes illegitimate. Some people may think if it gets bigger, it's illegitimate. Keep in mind, it got bigger to help Lincoln back in the 1860s. Lincoln obviously thought it was legitimate. He filled a seat. So I think it's the question of the legitimacy has to be worked out over time. I think it's going to depend on how the American people perceive it and how the court itself acts when these events help shape it.
Michael Moreland, your thoughts on if this really changes both the size and how we do this fundamentally changes, does that damage the legitimacy of the court?
I think it would, but it also maybe the fact that we're even having that discussion and as Michael Gerhardt says, the fact that so much constitutional hardball is being played around the court and judicial nominations culminating maybe in an effort to pack the court in a Democratic administration. I think it points out deeper questions that I think Americans have to struggle with about the role that the court is occupying in our public life. I mean, those of us who are a little more conservative would say that in some ways the court brought this on itself by inserting itself into a whole range of issues and becoming a kind of super legislature. And as Justice Scalia says in his dissent in Planned Parenthood versus Casey, people weren't up protesting at the Supreme Court when they were just interpreting statutes and deciphering administrative regulations. Now, there's a little bit of maybe a potted history there in that, but that by inserting itself into these deeply contested questions that the Constitution leaves to the political branches, the court has brought a lot of this onto itself. So I think the next iteration of this story is going to be the effort by the court, presumably with the Justice Barrett under whatever administration is elected in a few weeks, to try to safeguard its legitimacy. And of course, the Chief Justice, for institutional and I think sort of temperamental reasons, has a central role to play in this. But I think you've already seen some of that in some of the decisions, even the most recent decision about the Pennsylvania balloting a couple of days ago. And so I think you're going to see that play out in the next several years.
Somewhere in there, there's a hint of optimism. So I think I'll end with that. Michael Gerhardt, Michael Moreland, I thank you so much for a fascinating discussion. I have learned a lot, and I appreciate your time with us, but also what you do in your profession and in your civic life. And I thank you so much.
Thank you. Don't forget the second CLE word too. When you
I'm going to get to that in just a second.
Don't forget to
Thank
vote.
you. So thank you. And on that note, yes, right behind me is, I want to make a commercial for our newest exhibit at the Heritage Center, which is Ballot Box, America's Fight for the Vote. And it's a history of voting rights in the United States. We thought this was an appropriate time for all kinds of reasons, not least of which is the election coming up, but also the 15th Amendment, 150th anniversary of that, and the 100th of the 19th Amendment. So please come to the Heritage Center and see our great exhibit. We have other events and programs coming to you. Civil War Roundtable next Wednesday with Harold Knudsen on James Longstreet, Confederate General James Longstreet. He's always a fascinating character. Please join us for that. Thanks to the McCullough Center and Villanova University School of Law, I'm going to give you our second CLE word for all of our lawyers out there, and the word is leader. So I'm going to say that one more time. The word is leader. And for a reminder, you will need to complete the smart sheet that's going to be emailed to you from the Legacy Foundation, and you've got to complete that by 12 p.m. tomorrow for CLE credit. So thank you so much again, Michael and Michael. Thank you, everyone, for joining us. Until next week, have a good evening. Good night.